When CPS comes to your door. If you can, avoid ever getting on their radar. I would pretend no one is home, if that is at all possible. Now you should never avoid them if they can hear or see you or your kids inside. But if you can hide and make it look like no one is home and wait it out, eventually they'll leave. Usually initially, the complaint is not enough to give probable cause to go to a judge and get a warrant. But even if they did have one, if they do not witness any activity in the home, most likely, they will leave and not kick the door down. This was my experience anyway. They will try to make contact a few more times within the next 30 to 45 days, and if they can't make contact or locate you, they usually will have to close the case. Every state is different, so this is not going to be an exact formula for keeping CPS from entering your life and opening a case. Because once they have you and your kids in their jurisdiction, it's a very real possibility that they will take custody of your kids, and ultimately, the odds are stacked against you that you will get your kids back, and unfortunately your family will be destroyed by termination of your parental rights. If you are in the position of being able to relocate, to maybe stay with relatives out of state for a while, or if you can just pick up and leave, you have the means to do so. I suggest doing so now. But at some point, if you do not relocate far enough out of their jurisdiction or the county where they won't travel to, you are most likely not going to be able to avoid making their presence long enough and will come into contact with them within that initial investigation phase of 30 to 45 days. If you want to respond, talk through the door and be firm about talking through the door. Their main goal, or what they have legal authority, if you will, at the very least, is that they need to see the children. They will continue to pressure you to open the door, to let them see them, and that may not be necessary. Ask them if they have a warrant or court order, and if they did, they would have made you aware of it already. You may offer to show them your children through the window. And by doing this, I was able to get them to leave. And they will try to pressure you to let them in. Again, be firm and state that you just consulted with a lawyer and they advise that this is all you have to do, show your kids in the window. But doing this and reserving your rights may be held against you later down the road. 4. If you can successfully avoid, as explained in step number 1, without their detection of your presence in your home, they will leave their card in your door asking you to contact them. Now you can call them and ask them the details of the report made against you. And you do want to get back to them. Call them. Find out the details of the report and what concerns they have and offer to set an appointment to meet with them. Because they'll want to talk with you further and to see the children. It's better to be separated by more than just your front door or porch for that initial meeting. But if you wait and you have school-aged children, they will just go to the school and the school will cooperate with them and let your child be interviewed without your consent and without informing you. How you conduct yourself is very important. Anything you do or say will be used against you. Always remain calm, talk in a friendly tone. Be polite, always. Because they will take the slightest defiance in your tone, personally. Try not to say too much, ever. They will never understand, never see your side of things. You can expect CPS to only give you half of the details that they are concerned about or working with on you. Now you've got to try to figure out who would report you to CPS. Hopefully you have a good idea of who it was. What is the complaint against you? Is this a completely isolated incident for you? Then you may be one of the few lucky ones who may escape unscathed with your kids from a CPS case being opened against you. They will talk with you and then close their investigation. This advice is coming from someone who has been retaliated against, and they, my neighbors, used CPS as a weapon of harassment. Are you dealing with a narcissistic baby daddy, or nasty neighbors or relatives, people out to get at you that they may resort to calling CPS? However you get to that step where they want to discuss the matter, be careful what you say. Anything you say will be used against you, I promise. If they ask you for a drug test, tell them you will comply with all court orders. 5. Start documenting every encounter, including contacts with your lawyer and your kid service providers if applicable, every phone call, every visit. Get a notebook for this, and if you are really crafty, you can get one with tab sections. Label each tab for visits, calls, emails, case plan tasks, court hearings. Be precise and document as many details as possible about everything, including contact person, contact number, date, time, description of the encounter, follow-up needs, etc. 6. Set up a separate email account just for CPS and court-related correspondence. Also save all court reports either in one folder in your email or hard drive, or print them out, and always keep them. 7. Also use a Google or Outlook calendar on your phone to make sure you document all these encounters as well. To remove kids from parents. They are supposed to get a warrant or a court order, or there must be an imminent danger or threat of harm to your kids present. But Clark County has a practice of removing kids without following any of the proper steps to do this. They illegally seized my children. No warrant or court order, so they did not have judicial authority to do so. nor was there an exigent circumstance or imminent danger present. But they did it anyway. Usually, the case is just opened, and they are very successful at tricking parents into handing over their kids, believing that they have to. They take your kids to Child Haven, and within 24 hours, your kids could be placed in a stranger's foster home. You will be notified of a hearing, the PPH, the preliminary protective hearing or the detention hearing, which must take place within 3 days after your kids were taken. Here's where the scam starts. You don't have a lawyer at this point. And unless you have $5,000 or half of that for a down payment, you will be attending the hearing without representation. Decisions about the custody of your child and jurisdiction is being assumed at this hearing. It will go very fast. Most likely, you will attend over the phone, or maybe the Blue Jeans app. It is so important that you address the court and tell them that you contest the removal. The judge in this hearing is not the judge you've been assigned if you have a previous or ongoing case with the department. Preliminary Protective Hearing, PPH. Purpose, 72-hour review, plus appointment of counsel, plus set adjudicatory hearing. Within 72 hours of a child being removed by CPS from his or her caregivers, a preliminary protective hearing is held by the court. Upon reviewing the information in the preliminary protective hearing report, filed by CPS, the court must determine if there is reasonable cause to believe that it is contrary to the welfare of the child to reside in his or her home or in the best interest of the child to place the child outside of his or her home and determine whether reasonable efforts have been made by DFS to prevent the removal of the child from the home. You will receive this report with no time to really prepare a response by the time you are scheduled for the PPH hearing. Your goal for this hearing should be to address the court on 3 things. Remember, you will not have a lawyer to speak on your behalf, unless you retained one, with a quickness. First, you have to address the court. May I address the court briefly? I want to contest the removal of my child, because it is. Fill in why it is contrary to their claims in number 2. 2. You must overcome the department's claim that it is contrary to the welfare of the child to reside in his or her home, or in the best interest of the child to place the child outside of his or her home. 3. Here's the golden ticket. You must argue that they did not make reasonable efforts, which caseworkers are legally required to do this whenever possible, and to refer for court intervention and placement of children in out-of-home care, foster care, only when children cannot be kept safely within their own homes. And according to Jennifer Coleman, Clark County District Attorney, in a YouTube video entitled CIP Compelling Reasons and Termination of Parental Rights TPR, for what she has to say. What are reasonable efforts? Not defined in federal law. Defined in Nevada law, NRS 432B.393, 4. Reasonable efforts have been made if an agency that provides child welfare services to children with legal custody of a child has exercised diligence and care in arranging appropriate, accessible, and available services that are designed to improve the ability of a family to provide a safe and stable home for each child in the family with health and safety of the child as its paramount concern. So, when are reasonable efforts required? There's 3 situations in which reasonable efforts are required. First is to prevent the removal of a child from the home. Second is to make it possible for a child to return home once removed. And third is to finalize the permanency plan for the child. A couple key things I'd like to point out is specifically when we're talking about removing the child from the home. Reasonable efforts findings are required to be made under federal law within 60 days of the child being removed from the home. So, it is paramount that these findings be made in the first order after a child's been removed, and that can be one of 2 orders, depending on how the child was removed. The first situation is when a child is removed by way of warrant order. That warrant order must have the reasonable efforts finding in it, and it will be the first order filed in the case. The other situation is when a child is removed due to exigent circumstances, and the child had to be removed to be able to protect their immediate health or welfare. In that situation, the first order entered in the case is the order from the protective custody or the preliminary protective hearing, depending on which jurisdiction you are in, and so it would be paramount in those cases that the reasonable efforts findings be put into that part. What happens is if the finding is not in the first order entered in the case, the agency will lose, or the child will lose, title, or eligibility funding reimbursement from the federal government for the life of the case. Once this mistake is made, it cannot be fixed. Reimbursement would be lost for the entire life, and there's no way to remedy it. So it's really important, especially for the judicial officers, to make sure that when they are issuing those orders, that the language is in there. In my case recently, my kids were removed from me one evening, when the caseworker and her supervisor were at my house because they decided that the in-home safety plan was ineffective. They abruptly cut my brief reunification of 2 months short. We just came home from McDonald's, and I pulled into my driveway when they snatched my children right from the backseat of my car. They hurled them into their county car and told me that we will discuss the reason the next day. No, they didn't have a warrant or court order. No imminent danger or threat of harm to my children was present either. Clark County Department of Family Services has a custom of regularly removing kids without judicial authority, which would mean going to the judge with their evidence to get a warrant or court order to remove kids. In my case, the court report they submitted stated that they determined there was exigent circumstances to remove my children. No, there wasn't. But you probably won't be allowed an opportunity to object to this in open court. And when you get a public defender appointed lawyer, if you can't afford one, they probably won't raise an objection on your behalf for this. My experience with my public defender lawyer didn't start out pleasant. She berated me over things in the report, which were not true about me. Nonetheless, she treated me like I was a criminal defendant, and she was prosecutor, and things haven't changed much with her demeanor toward me. And basically, she has only objected to about 10% of my concerns in court. The child will also be appointed an attorney through the Children's Attorney Project, CAP. CAP will generally request that the child be appointed an educational advocate and/or a PLR, person legally responsible, if the child has a prescription for psychotropic medications. The children's attorney is supposedly a volunteer and not handling any other cases or children. This person's job is to speak for your children, and it appears that my children's CAP is in bed with DFS and looking out for their best interests. They have a custom of recommending to the court to appoint an educational advocate right from the get-go. A total deprivation of the parents' rights. Coming up. The court will then set the date by which the state must file the petition for abuse/neglect, which must be within 10 days of the PPH, as well as the adjudicatory/plea hearing, which must be held within 30 days of the filing of the petition. See NRS 432b.470 and NRS 432b.530. Part 2 is coming soon. Thanks for watching.